All right, welcome to the Creative Finance Collective. If you're just now joining us, this is a time where creative finance attorneys in the space get together and talk about all things creative finance and answer any questions that you might have. If you do have questions, make sure to write them in the chat. We're monitoring the chat, and we're trying to, or we're going to take questions throughout the entire hour. So if you have a question, make sure to post it. Let me bring on the folks that are here so far. Alan, how are you?
Doing well, doing well. How are y'all doing?
Good. Elizabeth, how are you? Good. Uh, how's Texas? How's the weather over there?
Oh, right now it's beautiful, beautiful.
This is peak, huh?
Yeah, a couple more degrees warmer may have to go out on the boat.
Oh. Does the water get pretty cold this time of year? I mean, can you really go boating in the fall?
It does get real cold now. I have jumped in the lake in February after a sufficient amount of beers were consumed.
Not to be recommended, but always the best way to handle cold water.
Yeah, yeah.
Oh, that's funny. Well, I know we have a couple more folks that are coming on here. Um, we've been having a problem, Alan, with clients checking the correct boxes on forms. You see that a lot? Do you see problems in creative finance transactions when you closing it where they've not followed, or maybe they're using the right forms but they don't know how to use them?
Yeah, absolutely. And there's certainly a increase in that. I think due to the pervasive nature of the education out there about wraps and subtos, and so people are, maybe ready, ready, shoot, aim type of investors. So we'll get the seller finance addendum box checked off whenever it's a sub to assumption, what have you. We'll also get a lot of different things in the for our paragraph 3, the purchase price. It'll say payoff, mortgage, TBD, things like that, and so it's problematic. We try to review the contracts before everyone signs. If we can't, then we try to review them as quickly as we can right after we receive them.
Do you have clients that want you to prepare whether it's a purchase contract or other type of creative finance form that they can reuse from transaction to transaction?
Yes, and we don't. I mean, we have the Texas Real Estate Commission promulgated form,
Okay.
and that's going to be it. And then I do have a cheat sheet on how to complete it, whether it's a wrap or sub to, that we do hand that cheat sheet out. And then we have some people who say they want us to draft the entire contract. And I said, well, if you want to pay me 1% of the deal to fill out the name and address of the buyer and seller, I can do that. But
Mhm.
we try to push them off.
So you basically try to give them information on how to fill out the forms that are available.
We do, we do. We I decided a long time ago that me providing all of that information will only just help my office. Some of it might be proprietary in terms of the extra things we're doing on the power of attorney or this, that, and the other, but it ends up helping the office so much. I'm finding that people want to steal my forms and things like that. And then also after a receipt of contract, I'll even sit down with people. I say for an hour, but it never takes an hour, with the buyer, seller, and this is usually on the consumer side, the end user, seller, end user, buyer. I'll sit down with them for an hour, and I have a meeting tomorrow in person, where buyer agent, seller agent, buyer and seller are coming, and they're going to ask all the questions that they have. And again, me spending that 1 hour of time is saving a tremendous amount of cost in my team's time.
Well, that sounds like a good approach because Elizabeth, correct me if I'm wrong. We've got folks that we've worked with that, if they do a number of these deals, it starts to get expensive. Like you said, if you're going to use a lawyer for every single nuanced transaction. So they want, to make that maybe they want a purchase contract that they can use that's better than the realtor or the forms that they have here in the States. So we provide them with a form to try to make that job as easy as they can. But then what we find is that they don't even know how to use that form. Elizabeth, didn't you run into issues like that?
Yeah, it was like under the purchase price and how they were going to pay, and they checked like all the boxes, and I was like, I don't think you're doing all of this for financing, because it's a little more straightforward than that. So then it's, either they're not paying attention or they don't realize that you're not supposed to check everything.
Yeah. So it looks like the way you try to kind of manage through that, Alan, is offer like kind of a consult to walk through it and make sure they got it right.
After the contract's receipted, not before.
Okay.
So we want a receipted contract, and then we answer all their questions. And then we'll lose some, but at that stage, they've gone through the frequently asked questions document. They've read our process document. If they come and start asking me questions that are covered on my FAQ document, I'll call them out and say, hey, I'm not going to read the document for you. Read it first, and then let's ask questions.
Yeah. If you're just now joining us, as the Creative Finance Collective. So we're taking questions throughout the entire hour. We're here from 3 to 4 Arizona time. That's a different time if you're watching from another state. But we're here now, and we're here through the rest of the hour. So if you're watching, post a question there. We're happy to take it. Alan, offline, we were talking, a couple weeks ago, we had a discussion, pretty in-depth discussion about solar panel liens. And you mentioned you have been working on that in more detail. What additional have you found?
Well, so I've been waiting for someone who's coming where the solar liens causing the deal not to be viable. The seller in a position where they don't care if there's a default and a risk of the solar panel company coming after them. And what I ultimately want, and this is, I guess, my question to y'all, is I want the transaction to complete. The UCC one is going to be moved over to Schedule B. I don't even know why the underwriters have it on my title commitment in the first place, because it's not a lien against the property. It's a right to go after your attached to goods, but that I'm not going to win that battle. Then after close, I'm going to represent the new owner and say your UCC1 recorded over in the property records is clouding my client's property, and I want you to release it because you only have a right to the goods and not the real estate. And then I'm also going to watch and see if they actually do go after the seller, but I don't think they're going to do that either. So that's my plan. Is there a flaw in my plan from what y'all see?
Sean, I know you've got opinions about that.
Oh, sorry. I thought I was mute. Brian now has told me that my typing was loud. No, I agree with your plan. Like I said last time, and, Drew Jenkins and I had an interesting discussion, but it bothers me that these solar companies take the position that their panels are personal property, and any UCC1 lien that they have, personal property lien, isn't wiped out through the sale of the, a foreclosure of the real estate. And they take that position, but at the same time, they go and record a fixture filing. So if it's a fixture, in that case, the foreclosure would wipe out the fixture filing, and the panels would be owned free and clear by whoever the third-party purchaser was at the foreclosure sale. But then they try to say, well, no, it wasn't a fixture. These aren't fixtures. This is personal. Well, then why'd you cloud title and record a fixture filing?
So I got into a pretty in-depth discussion with one of my escrow officers, and dealt with that exact same thing. I said a foreclosure is going to wipe out that UCC lien, even though I don't like calling it a lien, and should be taken off of my title commitment. And she said it's not. The underwriters want a release for that, And I said, well, you're talking about from a business perspective versus a legal perspective. I think by law that UCC lien is gone, period, unless it was a purchase money loan simultaneous with the purchase of the property and the solar panel liens. They could stay there, but they're never that way. So,
Right.
So my next battle is going to be that argument with the underwriting council as to whether the foreclosure wiped that lien out or not. And I mean, it may be one of those things like here in Texas, quit claim deeds are legal to use. Underwriters don't accept them. So it may be that type situation where legally I'm right and business wise I'm beat.
Well, we had Elizabeth and I had a matter where our client was a successful purchaser at the trustee sale, and they went to convey the property, which had a solar panel fixture filing junior to the deed of trust that was foreclosed. And they opened escrow, and the title company was like, oh, no, that they still have a lien. And we're like, no, they don't. This was wiped out in the sale. They, when they recorded their fixture filing, the deed of trust that was foreclosed and for which we were the successful purchaser at the sale had already been recorded. They knew that they were junior to us and they were wiped out. And they said, well, yeah, but just because it wipes out the fixture filing doesn't mean it wipes out the lien against the solar panels. And so they wanted to basically have some thing signed by the seller and put an exception on the policy, and then not seller, the buyer, and put an exception on the policy. And finally we told the client, we're like, hey, if this is how it's going to go down with this title company, you may want to look at going somewhere else. And I think they did, if I remember correctly,
Yeah.
who then insured it and did not list the UCC, and other information about the solar panels as an exception. They found a title company that wouldn't do that, and they closed through them. So,
I mean, I think it's wrongful conduct for them to come and cloud real property, intentionally cloud real property. They've got their UCC state filing,
right.
And so that's going to be my first. I'm hoping this one closes so I can then go and tell them it's an absolute wrongful cloud on title, slander title, and start threatening a lawsuit. And then, once we're successful 1, 2, 3 times, then we just start coming at them, from all sides.
Well, guys, so good answer, by the way, Alan. And in the last week, I sent out 3 letters to solar panel companies and 1 water softener company. That was very nice. And I included in my letter a release of real property as to the UCC lien. Even though it doesn't attaches, I think the title companies still want they want those to be removed. We've already talked about that in the past. I did talk to one of the solar panel lenders called Good Leap.
Yep.
That you may have heard of.
Mm-hmm.
And they actually said, yes, they would sign the release. I went,
Oh, wow.
are you? It was incredulous. It's like, really? But, again, it's been about a week. Everything went out to them, and we'll see if we get them back here shortly. But, if they don't get them back to us within a very reasonable time frame, I'm in your camp. We are going to file suit for trespass to tried title and hit them up for not only damages but attorney's fees.
Mm-hmm.
And my litigator, we've been planning this now for a year and a half. They're just getting more and more prevalent. But we're going to go after them, and we'll go attach all their daggum UCC liens until we get paid in full. So you just get. I think I may have brought this up last time or time before, where, Alan, here in Texas, they created that statute for removing a judgment lien on a homestead. And you'd hope that they would think about that a little bit and removing a UCC lien that's been filed in deed records as an easy, application process without going through all this crap.
Mm-hmm.
Yeah.
Since you're in Austin, I want to volunteer you to go down and talk to them.
Yeah.
You're so good at all that.
Yes. Yeah. Well, I mean, we have a closing. I think it's about a $320,000 contract price, fair market value, what have you, and an $80,000 solar lien.
Mm.
And that's just, I mean, that's just horrible that they're doing that.
I got you beat. I just
Okay.
sent one out at $105,000.
Mm.
I saw that, and it's like, what the hell did you build? Like a whole, array? What was that old movie, guys? Sahara. I don't know if y'all ever saw that movie or not. And it was all about, out in the desert, and they had this huge factory with solar panel arrays. Anyway, that's what came to my mind when I saw that. It's like, how the heck do you spend $105,000 in solar panels?
Does I don't know if this is not a creative finance question, but I guess maybe a relevant one to solar paneling. Does it even pencil out anymore? Is there any universe where without some massive subsidy, it even pays for itself? At the prices you guys are talking about, I haven't done solar, but boy, it sounds like it's far away from making sense.
I will say I have seen a few that are reasonable that probably make sense. They're all well under $30,000 and probably even under $20,000. And with the amount that the payment is and the return they probably get on their electrical there is probably an upside benefit. And you probably get the feel good thing going, look at me, I got solar panels and I'm going green or whatever it is they're doing, But once you get over that $30,000, $35,000 mark and you get these high payments, even if it's a low interest rate, it just doesn't work.
Yeah, interesting. If you are just now joining us, this is the Creative Finance Collective. We're taking questions. So if you have a question related to creative finance, make sure to put it in the chat. We'd be happy to talk through it with you. Alan, we were also talking offline. You mentioned a pretty complex issue you ran into dealing with escrow. Why don't you explain that for the group?
Yeah, so I was gonna put it in the chat if I didn't have a chance to ask it. What we're so obviously been working with mortgage wraps for a little while, and just got asked by one of my escrow officers a question on the escrow. So you got yourself a consumer seller. Let's say they're on month 8 of their escrow period for insurance, and they go and sell it. And since they're on month 8 of their escrowing of insurance, that's all paid for the next policy that's due. Mm-hmm. And so we have a savvy seller on this transaction. They said, "Hey, I need the refund for my 8 months that I paid in." Our knee-jerk answer is you're going to get a refund from your insurance that you have in place when you cancel it, but that's only 4 months that they're going to get reimbursed for. Where is their 8 months worth of escrow that was designed to pay for the next year's insurance? And I'm scared. I don't know if I'm thinking about this wrong, but I'm scared that we've done every single mortgage wrap transaction wrong for the past couple decades.
Because of that?
Well, I mean, first off, does the question make sense? You're prepaying for the next year's payment of insurance. That seller should get that refunded at time of close, kind of like prorating your taxes in a conventional transaction.
Yeah, well, I make it a little bit more simplistic than that, Alan, in that I include a document where there is an assignment of the escrow account. And so I have actually never dealt with that question before from any, home seller. But the way at least I try to avoid it is I have them execute an assignment of the escrow account. And even though it may be just as you laid out, where there's 8 months of insurance sitting in there or something of that nature, it's just part of the transaction. Now, you ran across a savvy buyer, or a savvy seller.
Yeah.
Which, I think you and I would probably ask the same question if the buyer's going to get a new 1-year prepaid policy of some type or things of that nature. And again, I will, in all honesty, since 2009, that's the first time I've ever heard that question come up.
Yeah, I was embarrassed. There was actually more than one person in the room. There were 2 escrow officers and an assistant. I was like, gee golly whiz, I don't know. I think we've been doing it wrong. But we assigned the escrow account over there because they need the taxes. They need to be assigned those taxes if there's an argument, dispute, what have you. But I'm amazed, and this was just 15 minutes before we started this, so I haven't crawled into a corner and started thinking about it from many different sides. But it seems fundamental that if I prepaid 8 months worth of an insurance policy that we're no longer going to purchase for me, I need to get my 8 months of payments back.
Well, first off, there's a contradiction in terms there, Alan, that you're going to crawl into a corner and think about it, okay? I'm kidding.
It happens.
You got to have a little bit of fun with lawyers every once in a while. But, again, I hear exactly what you're saying. And, when someone buys a property subject to the existing debt, that's the mechanism of the transaction, I think that there is a presumption that they're not only taking over that loan, but they're also taking over any escrow within the transaction. And so unless, the seller, like in this instance they did, ask for a reimbursement in some format, that becomes a contractual negotiation between the parties, which they can do if they wish to do it. And maybe all the people I've dealt with just hasn't been intelligent enough to ask that question. But goodness, I have actually never had that question come up at the closing table or in the contract phase ever.
No, and ours is of course post close, and they're going to be poking at us for a little bit probably. But I'm going to have to change my assignment of escrow to take care of this. I'm going to state that we're assigning escrow, and it includes any accrued but unused dollars for the hazard insurance policy.
Well, that's
Alan,
what an assignment means. Hey, we're assigning it. Whatever it is, it is. But I get you. You can be more specific like that, I think.
Yeah.
I don't think you'll run across it too many times, though, Alan, just from my experiences.
Yeah. I mean, the bigger question, Alan, is does this change the title of your 1911 letter?
It's going to be in the same. No, it's the same notice. It's still a revolver.
Okay. Okay. Yeah. All right. Interesting.
I'll let y'all know next week if I get any trouble from this. I guess we'll call him a bean counter, an accountant or something, an engineer maybe. I don't know who the seller was, but I'll let y'all know how it turns out.
Okay, Alan, be careful. I'm an engineer too. Okay.
Well, then you understand.
I'll tell you guys a funny story a little bit. So when you're in this business long enough, and in the title business, you start to learn people's personalities, right? Mm-hmm. And who you want to close, who you don't close. So let's see how good you guys are at guessing. What's the number one worst person to close in a let's call it a title transaction?
It's got to be attorney, doctor, or engineer.
Well, attorney's number one, right?
Mm-hmm.
So what's number two?
I'd go engineer.
Engineer. And by the way, guys, I got both those covered, okay? So stay away from me. So number three.
We got to stay politically correct, so I'm not going to answer.
So I have found that the third worst one is a military officer.
Oh.
They read everything to the nth degree, it seems like. And not too long ago, I added a fourth to it, and this is really going to throw you for a loop. I'm not even going to ask you because you'll never get it. It was a musician. And it's like, are you kidding me? I mean, it's like reading every line, doing this, asking questions. It's like, time out, go hire a lawyer somewhere. You should have done this, weeks ago, but not the day of closing. But
Scott,
there's your item.
Yeah, I represented an engineer once years and years ago in a litigation matter, and he got his bill, and we were we had been litigating and fighting, but most of the billing had to do with a motion for summary judgment to try to bring this case to a close. And he was really upset that there was billing on there for research. And he says, it's like, when I went to engineering school, I learned everything I needed to know. And what's the matter? Did you not learn everything you needed to know in law school? And I was a young lawyer at the time, and I was pretty proud of my response. I was so taken aback by it, but I was like, look, if you want me to try your case with the law as it was when I went to law school, we can do that. But the law is a growing, moving, evolving thing and has changed a lot since I graduated. So yes, you're paying for the research, buddy. But he was very bothered by that. If you are just now watching us, we are doing the Creative Finance Collective. So if you have questions, make sure to post them in the chat. Guys, we have a couple questions. So I'm going to read them off here and see what you guys have to say. First question may be from the same person. We've got two, but it's a Facebook question. They start off with dumb question, and I don't think this is a dumb question at all. I'll let you guys decide if it is, but I don't think so here. Is let's see, lost it here. Okay. If I'm buying a subto in a trust, is a wraparound mortgage required? Question mark. Is a wraparound mortgage required just, I assume they mean, or is it just required, a wraparound mortgage required just when you buy in an LLC? So first part of that is a wraparound mortgage required. Is it required just when you buy in an LLC?
Well, before all of us answer this question, I want to propose that.
I knew this was coming.
I like this. All right, Elizabeth.
Can I phone a friend?
Well, let me provide a little more context, Elizabeth. They also say, is a wraparound mortgage required for any subto deal? What's the purpose of a wraparound mortgage? Thank you all for taking the time out of your evening to distill this. Do you always need to do a wraparound? Well, what does it always have to be maybe that complicated? Even though.
All right, Elizabeth, you and I have gone over this tons of times.
I mean, you need to do a wrap to protect the seller, right? Because if you don't, then they don't have a recourse to come back. The buyer stops making the payments and everything. So it's best practice, yes, to do it. It won't matter if you're in an LLC or a trust. You should do it.
And will our office be involved or prepare any paperwork if it's not?
No.
Nope.
No.
We will not.
We will not.
Yeah. And there are plenty of folks who, do you technically need to get that done to do just a plain subject to transaction? You obviously don't. We've talked about this kind of stuff, but old fogies in the room, the judges with the black gowns, they haven't heard this term subto, but they have heard the term wrap a lot of the times. And that's a transaction. I remember Sean, we used to talk about wraps during the last recession when we couldn't get deals done, but nobody was talking about a subto back then.
Right.
And one of the nice things about a wrap is if you get in front of a judge, they, at least the ones here in Arizona, there's a good chance they have an idea about what you're talking about. There isn't some education process.
Well, and Brian's on here, and I'd like to kind of hear his thoughts from a litigation perspective. But I know that Brian's had a number of matters where our clients have either closed or they're in the process of closing. And one in particular, we had a very, well-known and, frankly respected real estate attorney here, litigation attorney, who sent a letter post-closing to our client all about the exotic transaction that he did and all of this. I don't know if his client failed to show him or failed to disclose it, but nowhere did his letter mention or deal with the fact that there was a wrap note and wrap deed of trust that was executed and recorded. And we just, in our response letter, just shoved that down his throat. Like, This isn't exotic. This has been around for, ages. Like, what are you talking about? You know this. And just like hand it to them in a response letter. I don't know that we could have done that if it were just a straight subject to without that note and deed of trust. I mean, Brian, what's your take on it?
Well, just as an aside, I think that I think the arguments that this particular attorney was making was not completely honest with us. I think he's making, he knew better.
Right.
But yeah, it's the way that these transactions are set up in the documents that our firm prepares are in my view completely defensible. Obviously there are people out there doing transactions that are much less defensible, and I think this whole idea of a wraparound is sort of one of the linchpin sort of elements of this transaction that gives it much more legitimacy, and you can really stand behind them because it provides protections on both sides of the transaction. So anyways, that's my quick take.
I'm curious, Scott, I know you wear a couple hats, and one of those is the investor hat. And, obviously lawyers can be accused of maybe overselling stuff sometimes, or being overly protective, or whatever else. But when I think about a wrap, I think, well, why not? I mean, I guess it's a little bit more in terms of documents, a little bit more in fees, but is it that much more? Is there a case for a why not in your kind of eyes as an investor?
I also have one of these little tin foil hats I wear occasionally too. Just FYI. So I kind of get out in left field every once in a while. But, let me tell you the take I have on a subto versus a wrap and things of that nature. So, and both from an investor's perspective as well as from attorney's perspective. To Elizabeth's defense, if I get asked to represent a seller in a transaction, which, by the way, guys, we're closing agent. They never ask to retain us as their attorney, ever. So if a seller is going to subject to them do a full wraparound mortgage, and it may even be what we call a mirror wrap. The wraparound mirror the existing first mortgage. Great, I like that because it does give seller, a URA note. It gives them a little bit more security and things of that nature. If they want to build in a balloon vehicle, go for it. It's easy to do at that point in time. However, from the insurer's perspective, investors do not want to do that because they do not want to take on the liability of an additional note that they're signing, which is, I think, subject to out there. And again, I kind of jump back to the old FHA non-qualifying loans back to the 80s sometime along the way, where you assume the debt, zero ability, you just take it over and start making payments on it. And it's similar to that thought process. And so most investors I know would prefer to draft a subject to, and if there's something additional to add to it, give the seller back a second lien mortgage, which of course on that instance. Now, we do a subject to deal, at least the way I do them. I offer back a deal. So I always want my seller to have a traditional mechanism to regain ownership of the property, i.e. a foreclosure. And here in Texas, on an investor transaction, we can foreclose in as little as days. I mean, you can rock and roll in that puppy pretty quick, unlike you guys in Arizona. That's more like 6 months to do there. But
It's not.
I would just always do with a deed of trust. now not have a note to sue under or things like that, but they can regain the property through a traditional mechanism. We do have someone in tech does closings who does not give the seller back a deed of trust, and it's not my knowledge. And they actually have this the on a document up that they're not getting one, and that their only recourse in the transaction is to file a lawsuit against the West Pasture Tribe Title Act. And I think that is probably the worst you can have there. So, if we're talking the seller representation, I'm with Elizabeth and with you guys to do a wrap if I'm presenting them and someone action along the way. But if we're going to do a subject to, but we're going to ensure that the seller always protect with that bare minimum a deed of trust along the way.
Yeah. Well,
So, Alan,
I
your
feel like I'd be.
commentary?
100% always have a full set of loan documents for any type of subto or wrap transaction, period. And I think like I understood y'all, if they want to do something different, they can go somewhere else.
And if you want to learn lots about wraps, Alan, you got a whole university, right?
Yeah. I had a new escrow officer join up with me, and I said, "Hey, you need to go ahead and attend my mortgage wrap class." And she goes, "Okay, yeah, that'd be good." I go, "It's 4 hours," and she wasn't as happy.
That's good. Well, if you're just now joining us, this is the Creative Finance Collective. We are talking about all things creative finance, and if you have questions, we're taking questions for the entire hour. We just spent a little bit of time talking about wraps, to do or not to do, why we like to do them as lawyers, the benefits that they provide, and that came from a question. So if you have questions, make sure to post them, guys. We have another one. Let me give this to you and see what you think. If I sell on a lease option, is there a dollar amount limit I can take from the buyer? ? Is a lease purchase the same?
So it depends on what state they're in. In Texas, pretty much can't do them. If there's an underlying mortgage that's not consenting and it's longer than 180 days, lease purchase option is not possible. I don't know of any limit on the dollars that you can take us down if you are going to comply with the statute in terms of Texas.
So, Alan, I'm curious about that.
Alan,
and I'll talk about
there.
lease options here. So is this only residential, or does that apply to commercial as well?
Just residential. There's a definition for residential. I think it's presumed if it's a half acre, maybe an acre or less, presumed residential, but it's a rebuttable presumption.
So if in Texas I enter into a purchase contract on residential property that's longer than escrow is going to be longer, not that you would ever do it, but escrow is going to be longer than 180 days, that's invalid. We can't do that.
No, you can.
Oh.
Only if there's an associated lease agreement with it.
Okay.
And we've had escrow for longer than 180 days before.
Okay, so you can, but if you have a lease that's associated with that property and the same parties to a purchase contract, then you can't do a purchase contract is over 180 days for escrow.
Yeah. The criteria, and this is just me reading the statute 127 times, is if it's existing lender not consenting to receive payments from that new tenant buyer and longer than 180 days, then it's not allowed per the statute.
I see. So to address the issue in Arizona, because lease with options to purchase or leases with, or a lease purchase, which would have a purchase contract in place with an extended escrow, are allowed in Arizona. And frankly, the option fee is what you can negotiate up to the point of a level of unconscionability. And so, if it's reasonable and makes sense and will not be deemed unconscionable, whatever that means. One judge could find something, or one jury could find something unconscionable, another thinks it's just fine, or but you have to kind of balance that out, and keep in mind that the way I see it is the more you collect up front, the bigger the argument's going to be by the optionee or the lessee that they have a property interest in the property, and it'll be more difficult potentially to evict and to terminate and the whole thing. Because then you got a situation where, courts are, they're looking to protect the consumer, right? And so you just have to kind of balance the equities and make a determination, but we have no set statutory amount as to what that is. You just, determination of, unconscionability and reasonableness, and just know that if you structure it right, you should be able to evict without any, property interest issues. But, if you can walk in and say, well, I've paid this person $200,000 for an option agreement, JP may be like, oh, no, go to civil court and figure this out,
That's a good point. And I need to put an asterisk. You can have a lease and a option agreement. It's when there's a price set certain. So if you have a right of first refusal or something of that nature, that can exist. It's when you have an exact amount, X dollars are going towards a purchase price. Purchase price is X. That's when we get into trouble.
Understood. Yeah. What if no portion of the rent?
Yeah, I've got an agreement though here in Texas
goes to the option.
Go ahead, Scott.
No, I was just going to say with Alan there, with the change of our, going back to 07 and 09, the 180-day rule kind of applies out for the most part. And when they die away from it, and you clients kill it at 179 if you're going to do one, and thereafter you got to work on a handshake. You cannot work on a document. There is a possibility if the investor, let's say it's an investor, is able to obtain written permission and do several, I think there's 3 by statute, you may be able to go up to 3 years, but these investors just aren't going to get lender permission to do that. And so the 180 applies. And so the question was, a lease purchase, which of course, I think they're similar, but they're different. Lease purchases, typically there's some money going by from the monthly income towards a future down payment or closing cost or principal or along the way. And what I think Al and I are jealous about is here in Texas, we're our hand, we're left and right, and you guys in other states out there can use lease options, lease purchase deeds, etc., land contracts, whatever you want to call it. And we can't. Everything is so damn problematic.
Yeah.
Well,
Go ahead, Alan.
No.
All right.
well,
If you're just now joining us, this is the Creative Finance Collective. We're talking about all things creative finance. If you have questions, make sure to post them in the chat. We're happy to take them, and we'll be here for another 12 to 15 minutes or so. Alan, you have a fan that's watching, and they've asked about how they can be a part of the RAP University. I have just put a QR code from one of our earlier shows. I still have it, which should have a link, but in case for some reason that is wrong and that link doesn't work in the QR code, for those that are watching, how can they attend your RAP University?
So the easiest way, I just now tested that QR link works, but easiest way is just go to our website, which is seshker.com, CESHKER.com. And it's the sign up is on that. I love that QR code. I wish I knew how to do it.
Well, that's what, yeah, it's easier than you'd think. In fact, the last time I think we did it, you had 2 or 3 people zap that thing and go ahead and attend. I had created a whole bunch of QR codes for all of our guests that came up, and that have been a part of it. And the biggest letdown I had with the software is it only lets me post one at a time. But let me see if I've got in any event. So I had that one handy. So just scan it and go right there. In any event. What else is going on, guys? Any other creative finance problems anybody's run into? What's the biggest? Is there a new recent trend, Brian, in litigation that you've seen relating to creative finance?
I mean, I think the thing we had most recently come up was that letter that Sean described. The other thing was, we were talking about the lease option. We actually had the unconscionability issue come up. Just when was that? Late last week, where someone was taking a fairly large upfront payment for the fee side of the lease option, and probably was crossing over into unconscionability, and so had to advise them on that. Just because someone will pay you a certain amount for that fee doesn't necessarily make it legal. So I would say those were the 2 issues that we've addressed most recently.
Before you got on, Scott, we were talking about clients having difficulty filling out the form contracts that we've prepared, either for them or the standard, or just the standard forms in their state that they're using. What do you have to do to make sure that stuff's filled in correct, or do you just get it all wrong on the back end and fix it when you get there?
We from the repertoire. I mean, I just don't trust the investor to fill it out correctly unless they're fairly sophisticated in the industry. And so we see so many rinky-dink contracts, these 1-page, 3-page contracts, and then you get the Pace Morby contracts that come in that are pretty decent degree. It's just that they fail to adhere to the requirements for Texas, unfortunately. And
well, the more important
kind of things.
The more important thing, well, not more important. An additional very important thing is the escrow officers are not used to these foreign contracts. It's just a hotbed for errors and mistakes and oversights. I mean, again, the Pace Morby contract is good. It's damn good. It's replete, but I don't know where special provisions is. That's paragraph 11 on my. I don't know where the purchase price. That's paragraph 3. The broker disclosure. We know ours, and if you start bringing in an out-of-state contract to a state that has a promulgated form, accepted by everyone, known by judges, juries, attorneys, agents, escrow officers, you just got to use those state promulgated forms.
Yeah, and
Alan,
we've talked about this.
Yeah.
We've talked about this, and of course, Pace is located in Arizona, and here in Arizona, we don't have state promulgated forms.
Yeah.
We have the Arizona Association of Realtors forms, but those are copyrighted, and you have to be a realtor to use them. And you can't just, nobody can go and just, duplicate them and use them. And plus, I will tell you, those forms do not do a very good job dealing with subject to transactions. And they require a lot of work and modification to make them work for that. Unlike your guys' forms that I think has a loan assumption addendum. Like, we don't have a loan assumption addendum. We have a seller finance addendum, but that contemplates a straight seller carry back where the property is owned free and clear. It doesn't deal with, the assumption of the loan. And you guys have that assumption addendum, which is, better than what we have here for our realtor form. So, but I think it's important for those who are doing business in Texas and doing subject to transactions in Texas to know we have 2 attorneys on here who are, closing attorneys, real estate attorneys, investors themselves, who are telling you to use the TREC form, right? The form that's been promulgated by the state because it's going to make their lives easier and it's going to avoid mistakes. And I'm sure both of you guys, if somebody reaches out to you, you can tell them, here's how to modify this form to work with my office so that it's a smooth transaction. So please, use, if you're doing transactions in Texas, you have 2 closing attorneys right here telling you use the TREC form and work with them to modify that to get it dialed in, because it will just make the process that much smoother.
I'm going to adopt
only
what
one
you just said,
problem with
mic
that.
drop, and I have to head out. So y'all continue the good fight.
All right. Thanks.
All right,
Alan.
Alan.
All right, Alan.
Scott, what were you going to say?
So, Sean, there's only one problem with that, big guy. You assume that they actually live us. Number one, they don't. We always suggest using a promulgated form. You try to tell them that we supplant our disclosure packet covers everything, because although we have the assumption addendum and we have a seller finance addendum, they are nowhere near what you need to have for this industry or this business. And so we incorporate most of the language in those into our disclosure packages to protect everybody. But again, they just don't want to do it. And what gets me too is, we keep talking about the same thing ad nauseum, where everybody just wants to make a fast buck. And, I had a deal where these wholesalers put a house under contract. They assigned the contract to the back end buyer, who calls me and wants me to take a look at things. I'm going, yeah, we got a problem because the seller didn't provide the proper disclosures. And everybody thinks that you don't have to have some disclosures that are required here in Texas if you are an investor buying a house as an investment property, but the seller is required to do it. Well, lo and behold, what happens? Well, the investor decides to back out of the deal. They want their earnest money back after all of their inspection periods, option periods, whatever it might be, is run. And we have a document here in Texas called the underlying lien disclosure notice, which is an obligated form that's mandatory by all sellers to provide any buyer, whether it's an investor or a homeowner, a minimum of 7 days before closing. If you don't do it, they have the right to terminate the contract for any reason at any time. So, and the sellers in this case didn't want to return their earnest money. And so I wrote them that letter going, hey guys, you missed 2 important things. You missed the underlying lien disclosure and the insurance disclosure. And here's what the statute says. And lo and behold, we got it released pretty quickly. But these investors, it's the greed factor. It's that usury factor. It's all they want to do is make that quick buck, that quick dollar. They don't really care about doing it right or wrong, which I don't understand that. There's a few who do, I think. And I know we try to promote this throughout Texas as well as nationally. But man, it's just get 2x4 out and wide the head.
Well, I get the sense that a lot of them approach this from the perspective of it'll just iron itself out during before close.
Yes.
Like we'll just sign here. We got 30 days. Everybody will be reasonable and everybody will be like, okay, yeah, that makes sense. Oh, I get what you meant. And we'll figure that out and it'll all work. And that's what the 30 days close is for us all to just kind of to fix our mistakes on the purchase contract side of it. And that's not at all what it's for. And there's not a lot of people that are going to hold your feet to the fire.
And on top of that, Andy, they don't want 30-day closes anymore. They want like 10 days and 2 weeks and let it all iron out.
Oh gosh.
And
or
I don't know
quicker.
about you, Scott, but yeah, I'm sure you see stuff and you're like, you can't even get HOA disclosures, in that amount of time. And yet, they're like, oh no, we can close tomorrow. It's like, you can? Like, no, doesn't work that way. And so they try to then work it out in like a 10-day close, and it's just a nightmare.
Yeah, that's
It is.
so true. Because I deal with it on the back end when the entire transaction implodes and there's lawsuits being filed, right? And the amount of conversations I've had with investors where we talk about, hey, look, here's how we make sure this doesn't happen in the future. And here are the changes that you need to make to your purchase contract. And the pushback I get is, yeah, but if I do it that way, it's going to be so much harder to convince the seller to go through with the deal. And it's like, yeah, well, the way you did it got yourself a lawsuit alleging that the agreement wasn't enforceable in the first place. So what do you want? Do you want to weed out the contracts that shouldn't be signed in the first place? Or do you want to get more contracts and just litigate them? And so that's, I think it's such a good point to make, and something that, for people who are just kind of getting started in this business and need to understand, just because somebody will sign something doesn't mean that you can always get, that doesn't mean that agreement is 100% binding or enforceable. And it's so important to make sure that your sellers have a very good understanding of what they are signing and what the terms of that agreement are. And you need to be walking through this agreement with them, and you need to be giving them accurate information, and you need to be able to show where in that agreement that information is. Which is why, on the forms that Sean has, you've got all these seller acknowledgments, right, that they have to initial individually, and why that's so important. It's, and just because you as an investor don't want to have to present an 8-page agreement to the seller, and you'd rather do it with a 1 or 2-page agreement, you either get the problems on the front end or on the back end. I'd much rather know on the front end whether there's a problem than on the back end. So anyways, I've run into these situations so frequently over the last 6 months that I'm glad you brought it up, Scott.
Well, I think the other danger too is, correctly, this is the case, but the gurus in the space, even the ones that are correct, are talking about build a team and get this done right. And get a good lawyer. But the thought of, I think people quickly jump to this idea that a good lawyer, if I've got Sean St. Clair or I've got Scott Horne on Texas managing my deal, they see that as like, well, I got a good lawyer. That's my get out of jail free card to just like kind of half-ass this thing and get it through. And they're going to like fix it for me if anything happens. It's like, no, they're there to make sure you don't screw it up and to give you advice on the front end. And I don't know if you guys run into that, but so often it's like, well, they just figured they could jam this thing through, and then it was just going to get ironed out by their great lawyer. And sometimes it gets ironed out, but man, there's a lot of times where that great lawyer has to tell you, yeah, you just obligated yourself to a really bad deal because you didn't paper this correctly.
Well, Andy, I mean, really goofy Texas, it seems like, at least at my may be the same. These investors, they'll bring us a contract, and of course, just because they're bringing the contract to us to close the deal for them in the law office, they think that we have to represent as an attorney. Is no, we represent. We're just a closing agent.
Yeah,
just like any other title regard. If you want us to represent you, we're happy to. We got to sign an engagement agreement. They will never do it, but they think they do. Now, to set that aside, we try to, make sure that they're being compliant, that things look good, and go above and beyond the call, without necessarily representing them, but we still make sure things are okay. If they're not, we kind of tell them what they need to do and why. But it's just that age-old cycle. Investors are just cheap. They won't drop the extra money for that person. They want everything, but not willing to pay for it. And I don't know if that will ever change.
Well, good discussion. We'll leave it there, wondering whether it'll ever change, and then address it maybe next week, whether it might possibly change. In any event, thanks guys for taking the time. We've been here an hour. We've got some good questions, and let's do it again next week.
We'll see you
All
guys.
right,
Have a
guys,
great
have a
day,
good
boys.
one. All right, bye.